Since August 2024, there have been significant changes to casual employment in Australia. The changes are part of the federal government's comprehensive reform of the Fair Work Act and its intention to improve job security for casual employees. I'm Anna Ding, solicitor at WilliamsonBarwick, and as a specialist employment law firm, we've analysed these reforms in detail. So in this video, I'll explain the new legal definition of casual employment, a new pathway for casuals to become permanent staff, and specific actions required by employers to stay compliant. Before the changes that took place in August of this year, a person was a casual employee if they were offered and accepted a casual job on the basis that there was no firm advance commitment to continuing an indefinite work according to an agreed pattern of work. Since 26 August 2024, however, Section 15 A of the Fair Work Act includes a general rule that an employee is a casual only if there is no firm advance commitment to continuing an indefinite work and they are entitled to receive casual loading or specific casual pay rate under a Fair Work instrument or the employment agreement. The law also provides specific guidelines to determine if there's a genuine commitment to ongoing work. These guidelines focus on examining the actual working relationship between the employer and the employee, not just what's written on paper. When determining if someone is truly casual, employers must consider: are there permanent staff doing the same work? Can the employer freely offer or withhold work? Can the employee genuinely accept or reject work? Is there likely to be ongoing work available? And whether the employee works a regular pattern of hours. Beyond the changes to how a casual employee is defined, there is now also a new pathway for casual employees to change to full-time or part-time permanent employment through what is known as the employee choice pathway. As a summary, casuals will stay casual unless their employment status changes, either through accepting an alternative employment offer and starting work on that basis, a Fair Work Commission order, or changing to permanent employment under a Fair Work instrument such as the National Employment Standards, an award or agreement. This includes the casual conversion or the new employee choice pathway. The employee choice pathway will be available from 26th February 2025 for most employees or 26th August 2025 for employees of small business employers. During the transition period, the current laws about offers and requests for casual conversion will continue to apply. Under the new pathway, eligible casual employees have the right to request to become permanent employees after 6 months of service or 12 months of service for a small business employer if they believe they no longer meet the definition of a casual employee. Unfortunately, they won't be able to give their employer written notification of their request if there is a current dispute with their employer about changing to permanent employment, or if they made a request in the previous 6 months. But if these circumstances don't apply and the employee chooses to give the notification, the employer must respond within 21 days and may only refuse the request if the employee still meets the definition of a casual, there are fair and reasonable operational grounds to do so, or accepting the notification would result in the employer not complying with the recruitment or selection process required by law. If the employee and employer have a dispute about the casual employment status and it can't be resolved at the workplace level, the Fair Work Commission now has expanded powers to deal with all dispute about this new pathway by arbitration, and consent to arbitration from both parties is not required. A Fair Work Commission member can then make orders it considers appropriate, including that the employee continues to be treated as a casual employee or will be treated as a permanent employee. These rights are now also protected under the Fair Work Act, making it illegal for employers to take adverse action against employees who exercise them. Now, let's talk about misrepresentation, another key change in the new casual employment laws. The law now prohibits two specific practices: misleading someone into accepting a casual role when the work is actually full-time or part-time, and dismissing permanent staff only to rehire them as casuals for the same work. Both practices can result in penalties for businesses and individuals involved. Along with these new rules on misrepresentation, the Fair Work Commission has updated all modern awards to reflect the complete set of changes, including the new casual definition, conversion pathways, and the dispute resolution processes. There's one final requirement employers need to know about: the Casual Employment Information Statement. This must now be provided at certain times during the employment relationship, including at the start of the employment and after 12 months of employment for small businesses. For all other employers, the statement must be provided after 6 months of employment, after 12 months of employment, and then again every subsequent 12 months after that. So those are all the updates to the laws around casual employment. If you're an employer employing casual staff, it's important for you to familiarise yourself with these changes and comply with the new provisions, because if you don't, it will result in penalties or legal action. If you have any questions about how this will impact your business, feel free to reach out to us.